co-counsel brought up the Rome Statute and customary international law. And here we are, the American Court of Human Rights. And I was just wondering, what's the relevance of public international law in your arguments? Why is your co-counsel even bringing those arguments up? Or why are you bringing this up in your memo?
Because customary international law will apply as a rule of international law to the state of Naira, regardless of whether or not it is a party to the Rome Statute specifically.
Okay, but my question is more basic than that. I mean, shouldn't your arguments just only be about, Inter-American Court of Human Rights jurisprudence?
Your Excellency, my co-counsel actually had an alternative argument which was based on the jurisprudence of this court, but she ran out of time before she was able to go through it.
Okay, so what then is the relevance of regional bodies like the ECHR to this case? Do you think they are relevant at all?
Your Excellency, they are definitely relevant insofar as the human rights treaties on which they are based have similar wording. So, and as well as the fact that the jurisprudence of this court regularly refers to that of the ECHR, and they have adopted specific tests from the ECHR jurisprudence as well.
Like what?
For example, in my second submission, in determining when the obligation to prevent arises, it is conditioned on three conditions, and this was adopted from the case of Opus and Turkey from the ECHR, and was applied in this court in the case of cotton field in Mexico.
All right, please proceed.
Your Excellency, my name is Bryan, and I'll be dealing with Naira's breaches of its international obligations in its dealing, or more accurately, its failure to deal with the series of assaults on Maria Quispe. In 2014, Jorge Perez repeatedly assaulted Maria Quispe, his wife, and in response to this brutality, Naira took no effective measures. Despite the extreme nature of the first assault, disfigurement with a broken bottle, no investigation took place because the only medical examiner in the area was on vacation. Furthermore, no protective measures were taken to prevent the subsequent two assaults in May 2014 and August 2014. With this backdrop, I will be making two submissions. First, Naira breached its duty to investigate the assault which Maria Quispe reported on the 20th of January 2014 by failing to take any investigative actions whatsoever. And second, Naira has breached its obligation to prevent the subsequent two assaults on Maria Quispe. Turning to the first issue, Naira has breached its duty to investigate when it failed to take any investigative actions after Maria Quispe reported her husband for disfiguring her with a broken bottle. This obligation to investigate arises from the state's obligation to ensure the right of humane treatment pursuant to Article 5.
Is this an obligation of effort or of result?
Your Excellency, this is an obligation of means and not results. And what this means is that
but you just said ensure. Ensure sounds a lot like result, doesn't it?
Your Excellency, ensure is the specific wording that was used in Article 1.1 of the American Convention of Human Rights. And in the case of Velasquez-Rodriguez, this has been interpreted to mean three different obligations. And these three obligations would be the obligation to investigate, the obligation to prevent, and the obligation to punish.
Which of these are we concerned with here? All three or just the first?
We are only concerned with the first, with respect to the first assault, which is the disfigurement of the broken bottle.
And with respect to the other two assaults?
With respect to the other two assaults, the state did take investigative actions. However, we are submitting that the state should have done more to prevent the assaults in the first place.
Like the second and third obligations to punish and...
we are not contending that the state has obligation to punish in this case, but there is an obligation to prevent the second two assaults for sure.
Obligation to prevent, so that's your argument for the two assaults, the subsequent two assaults.
Yes, Your Excellency.
How are the two different? Obligation to investigate and obligation to prevent, substantively?
Substantively, the obligation to investigate is to determine the truth of what happened in that situation, but the obligation to prevent is to reduce the chance of the danger occurring.
Okay, please proceed.
So, as I mentioned previously, this obligation arises from Article 5, where it's Article 1.1 of the American Convention on Human Rights. And once the state is aware of a potential human rights violation, the obligation to investigate requires the state to initiate an official investigation without delay. And this investigation must be serious.
What is delay? How many days constitutes delay?
Your Excellency, this court has not laid out in its jurisprudence a specific time period. However, the standard that the court adopts is one of reasonableness. And
have other courts talked about what delay might constitute?
What the delay might constitute. So
yeah, in terms of duration, what constitutes a delay? Have other courts pronounced on this point?
No, Your Excellency. However, in this particular instance, the delay was indefinite because the state took no action.
I want to take down my questions, by the way.
So, as I mentioned previously, this investigation must be serious, impartial, and effective. And in order to be effective, the investigation must be carried out with due diligence. And due diligence means that the investigative authorities must, within a reasonable time, take the necessary measures to try and obtain results. So this obligation is one of means and not results, and must be complied with diligently to avoid impunity and repetition of this type of act. This court has held that if acts breaching the victim's human rights are not investigated properly or genuinely, they will be, to some extent, assisted by the public authorities, which would entail the state's international responsibility.
International responsibility or regional responsibility? After all, this is a regional court we're talking about, yes?
Yes, Your Excellency.
So, explain what's the difference. Why international responsibility?
Your Excellency, I stand corrected. It should be regional responsibility, given that this court is a regional court.
Are there regional responsibilities in this context? Do Latin American states have regional responsibilities in regards to human rights?
They have the authority. They have the responsibility insofar as they have signed on to this treaty, the American Convention on Human Rights.
Okay, see, the thing is, I get erga omnes obligations. I mean, international obligations by virtue of actually, because now we think of human rights, we think of an international community now. Use Kogan's norms, higher values. But I was just wondering if this concept has actually taken shape in a regional context. So, is there any source, any scholar who has talked about a regional responsibility to ensure the human rights of Latin American citizens, a responsibility specifically to this organization of American states?
Your Excellency, I have not come across the term regional responsibility. However, I agree with your point insofar as this court is a regional court, and the state is responsible for its obligations, which is a regional treaty obligation.
Please proceed, yes.
So, on application to the facts, the Nairan police's failure to initiate an official investigation into the violent disfigurement of Maria Quispe constitutes a clear violation of its obligation to investigate the first assault with due diligence. In Naira, official police reports are only filed when there has been a medical examination done, and the sole medical examiner in the area was on vacation, meaning that this investigation was that Maria was unable to undergo this
examination. So it was his omission that was the problem, the medical examiner's omission that was the problem.
Your Excellency, it is actually the problem of the system as a whole, because there was only one medical examiner in the area that could have done. And in this case, our specific complaint is that the state should not peg its standard of investigation to the receipt of a medical examination, because there are a number of other alternative measures that could have been taken.
So what is the specific thing we are claiming? That the state didn't put enough doctors in one area, or that the state should have actually ignored that requirement and just been an exception just because the doctor wasn't there? Which of the two is it?
Your Excellency, our specific complaint does not actually fall within the two options that you have given.
Yeah.
Our specific complaint is that the state should have taken investigative actions and the fact of the matter is that it did not take any actions whatsoever. And in this case...
But it did so because of procedure, it didn't?
Yes, Your Excellency. In response to the state's reliance on its own internal procedure to excuse its failure to investigate, we have two submissions. The first is that there are many alternative measures that could have been taken, and we contend that these measures exist within Naira itself.
Okay.
And the second is that a state cannot rely on its own domestic law to excuse a breach of its international obligations. So, moving to the first point, which is that there are alternative measures.
Okay.
So some of these alternative measures that could have been taken include interviewing the parties and the witnesses, recording the complaint in detail, and filling out and filing an official report on the complaint. So state practice has shown that a number of other states to the ACHR have actually codified these potential investigative actions in their criminal procedure code. For example, Brazil, Argentina, and Colombia have all included interviewing the victims and witnesses as key actions to be taken when a report is made. And the existence of these possible alternative measures is buttressed by the fact that there are many potential violations of the ACHR which may not result in physical injury. And for the state to be able to effectively investigate those breaches of the human rights, there must exist certain investigative procedures which are alternative to the medical examination. And
alternative to the medical examination.
Yes, Your Excellency.
But is this even a requirement that we are comfortable dispensing with? Is a medical examination something we want to dispense with? Because this court is going to set a precedent. So,
Your Excellency, it is not our submission that they should do away with the requirement of a medical examination. But the point we're trying to make is that they could have done a number of other things to kind of ascertain what happened in that situation and perhaps follow on and to prosecute Mr. Jorge Perez in the absence of a medical examination. However, even if we accept that medical examination is so integral to the investigation process, it begs the question why the state failed to do this medical examination at a later time, when the medical examiner had come back from his vacation. And the failure to take any actions whatsoever, either through alternative measures or through a later medical examination, is a clear violation of his obligation to investigate this assault that occurred on the 20th of January.
Okay, please proceed.
And so the second argument that I raised previously about the state not being able to rely on its domestic legislation is based on Article 27 of the Vienna Convention on Law and Treaties, which states that parties may not invoke provisions of its internal law as justification for its failure to perform a treaty.
Okay, then my question then is, can a state rely on its regional obligations to avoid its international obligations?
Your Excellency, it is, I think Article 30 of the Vienna Convention deals with the conflict of treaty norms.
Is it really 30?
I'm unclear on this point, but it's somewhere between 27 and 30.
Aha!
Your Excellency,
Alright, go on.
However, it is not our position in this case that there are conflicting treaty norms. What we are contending in this case is that NAIRA cannot rely on its domestic laws, which states that in an official police report can only be brought. Official police report only occurs after the receipt of a medical examination to excuse its failure to investigate whatsoever. And this position is consonant with this court's holding in the case of Gulacio in 2003, that a domestic legal obstacle that attempts to impede the investigation is inadmissible. And similar to how in that case, Argentina could not rely on the lapse of a domestic limitation period to excuse its failure to investigate, it is our submission that in this case, the state cannot rely on its investigative framework to excuse its failure to investigate the assault.
Is that the only case you have on statute of limitations?
Your Excellency, there is another case, however, the name I do not have with me at this point.
Which you will eventually.
Which I will eventually, Your Excellency. So, in conclusion of the first submission, NAIRA's failure to conduct any investigation or collect any evidence whatsoever is in clear violation of its obligation to investigate breaches of the right to humane treatment pursuant to the American Convention on Human Rights.
How much time do you have?
I forgot to take the time. I have 6 minutes left. On the second issue, it is submitted that NAIRA has breached its obligation to protect Maria Quispe against violence by failing to take any form of protective measures to prevent further violations of her Article 5 rights to bodily integrity.
I was just wondering, resources are limited and scarce. So how is a state supposed to actually allocate its resources accordingly? Because you have this happening on a systemic level. This happens relatively often. This is obviously a very misogynistic, sexist, chauvinistic country and culture. So what makes her so special that she should take up the state's attention in terms of having any sort of violence, sexual violence perpetrated against her?
Your Excellency, we take your point that the state's resources are limited. However, we have 2 points in rebuttal as to why the state should take action in these types of situations.
No, not these types of situations. In her situation specifically.
Your Excellency, her situation specifically, the state should have taken actions because, firstly, the first assault on Maria Quispe was particularly violent, which was disfigurement with a broken bottle. And the second is that there was clear indications that the social and political climate in, maybe not political, the social climate in Naira is one where violence against women is commonplace and it does occur relatively frequently.
So a general question, Council, is this: can a state's lack of resources ever excuse its failure to abide by its human rights obligations?
Your Excellency, state's failure to the lack of resources as an excuse to to excuse its breach of its international obligations should not be accepted by this.
Not should. This is not a should not question. This is an is or is not question. But what international law or regional law says.
Your Excellency, in this standard the standard of prevention in this case is one of means and not results, so similar to that of investigation. And so the state, the obligation is only fulfilled if they take measures which would have reduced the risk factors. And in this case...
So more broadly speaking, is there any international treaty which takes into account a state's resources and financial resources, its ability to meet its human rights obligations and stuff, capacity? Is there any international treaty that does that?
Your Excellency, I am unable to assist you on this question.
Alright then, please proceed.
So, Naira's obligation to prevent the assault between private parties arises when 3 conditions are met. First, the state is aware of a real and imminent danger. Second, the real and imminent danger affects a specific individual or group of individuals. And third, there was a reasonable possibility of preventing or avoiding this danger.
Can you guess what question I'm going to ask next?
No, Your Excellency.
How imminent is imminent?
How imminent, Your Excellency, this court has not clearly explicated on what imminent means, and they have typically taken real and imminent together. In fact, they have taken these 3 conditions holistically, and they do not actually explain what the specific terms mean. However, it's submitted that we can use the case law as kind of a guide as to what imminent means.
Kind of a guide?
As a guide to what imminent means.
Right, but is there, so there is nothing in the case law of this region itself that actually may shed some light on what constitutes imminent threat or danger. What about other jurisdictions or regions? How do they define imminent? After all, we're talking about treaty provisions or legal terms. So how do other regional courts dealing with similar treaty provisions define imminent?
Your Excellency, I'm unable to assist you on that point.
Okay.
However, I do have a case from this court which does deal with the obligation to prevent, and this is the case of Cotton Field in Mexico.
That's not really helping, but go on.
So in this case, what happened was that the 3 girls went missing, and the state held that, this court held that the state should have taken immediate measures to try and locate these women because they were under a real and imminent threat of being subject to abuse and rape and possibly murder.
Okay.
And the reason why they held that there was a real imminent danger is because there was a general context of violence against women in Ciudad Juarez where the abductions took place. And similarly, in this case, there is a climate of violence against women and domestic violence. For example, in 2016, more than 60% of the women in Naira were assaulted by their partners. And in 2017, there were more than 85,000 instances where emergency services had responded to instances of domestic violence against women.
Okay.
And so these statistics are indicative of Naira's social climate, one where violence against women is commonplace and where women are afraid to report these crimes. And this fear is understandable, given that domestic violence commonly consists of repeated acts by the same offender. Thus, given this general context of rampant domestic violence, it would have been clear to any reasonable policeman that Maria faced a real and imminent danger of subsequent assault by Jorge Perez when she approached the police with a disfigured face. And under the third condition,
I'm not entirely sure about your logic here, because you're pointing out how it's very, very, very likely she would have been attacked again because there is a climate of domestic violence. That's the gist of the argument that I'm getting from you.
Yes, sir.
But we're talking about individuals who have agency, who make choices over their own actions, and how would we be able to predict what someone else would do to someone else? How would any police officer be able to predict that?
Your Excellency, the police officer does not have to predict when the assault will occur. However, the police just needs to know that the specific individual is in a situation of danger.
Isn't that some sort of prediction as well, logically speaking? It is,
yeah.
Isn't it?
To some extent, yes, Your Excellency. However, that is a prediction that's based on the statistics of the social climate.
But the statistics just tell us that there is domestic violence and rape happening. It doesn't tell us anything about how if you were hit once, you are likely to be hit again. I don't see anything on the facts here which suggests what you just said. That likelihood, how I put it, that there would be repeated acts of violence.
Your Excellency, I know that I have run out of time,
okay,
and I'll just take this question,
yes.
This last question of yours. So, in academic named Professor Alistair Burke has written a paper called "Domestic Violence as a Crime of Pattern and Intent," and in this paper he covers the statistics in the US which show that
in the US,
yes, Your Excellency.
How applicable is it to this context? After all, this is a very misogynistic, chauvinistic, sexist place, isn't it?
Yes, Your Excellency. If anything, it would be exacerbated. The findings that this professor made would be exacerbated in this situation, where there's a climate of social acceptance towards this type of behavior.
Okay. I'm satisfied with what you just said. All right.